On Monday, the Honorable Robert Kyagulanyi announced that he will be withdrawing his presidential election petition, citing bias and unfairness from the Chief Justice and other justices of the Supreme Court. This was after court twice rejected Kyagulanyi's attempt to file additional affidavits in support of his position challenging the victory of President Museveni in the January 14th elections. But is it a question of lack of evidence or Kyagulanyi's side, or being frustrated by the temple of justice? Tonight we host Jameson Karemani, Judiciary Spokesperson, Rubongoya, NUP Secretary General, and Enoch Barata, NRM Lawyer. Gentlemen, I want to thank you so much for having honored our invitation. A warm welcome to all of you.
Thank you.
I must assure you tonight, the spotlight of Uganda is on you. And we're looking forward to hear your submissions on this particular subject we are going to be discussing. Let me begin with you, Mr. Rubongoya. When you are the Secretary General of NUP, when the former presidential candidate was filing a petition to the Supreme Court, did you move to that Supreme Court with a sense of feeling that you could actually get justice from it, despite of what all that you had gone through in the election?
Thank you very much, and very good evening to the viewers. Of course, when we went to the Supreme Court, we expected justice. And like we said, there was a very, very huge debate within our camp. And the debate was about whether indeed the Supreme Court would do something different this time around. And first of all, do what the Constitution commands, have an inquiry into this election that in our view was not even an election, it was more or less a military operation. And many Ugandans said, don't go to the court because you cannot expect anything from there. The
inquiry and the petition are those two different things, Louis.
What the Constitution says is that the Supreme Court shall inquire into. But unfortunately, what the Supreme Court has done in the past is to handle it as a normal hearing. But that's a debate for another day. And if you look at Justice Kanyamba's dissenting judgment in the 2006 petition, you'll see his reasons for saying that this should actually be an inquiry which should be handled differently, and the reasons are very clear. But when we went to the Supreme Court, our view was, let's just give a chance to this other institution. Let's allow them prove us wrong.
So you're telling Ugandans, Louis, that when you walked into that Supreme Court, failing that petition, you had no doubt in your mind that this Supreme Court was going to give you justice, only 2 weeks later to say, oh no, we are wrong.
Like I said, look at what has happened in the past. Look at what the Supreme Court has done, especially when the tenure of President Museveni has been at risk regarding the presidential election petitions right from 2001, regarding the recent age limit case, and whatever has been happening. So many Ugandans were saying going to court is a waste of time.
But what were you saying as NUP?
We were saying, let's give these guys a chance. Let's give the court a chance to prove itself right or wrong. Because we believe in the rule of law deeply, deeply. We may not believe in the people who sit in some of these institutions, but we believe deeply in constitutionalism and the rule of law. And that is why you've seen us subject ourselves to an election, even when we know that the electoral commission is biased.
One of the key issues, Louis, that you talked about was the 3 people you wanted to recuse themselves from the court. You went there knowing these were appointees of by the president, by the virtue of the authority that he has. And how could you go into that court? You have doubt about these 3 people, but still you think you're going to get justice. And in the middle of the petition, you raised those issues, yet they were there at the beginning.
The laws of this country allow you to file a case and then demand that justices recuse themselves. And mind you, even when we raised it at a press conference and said we are going to apply that these judicial officers recuse themselves, they did not even allow us an opportunity to reach that level. These people showed their bias ab initio.
But did you have to say that at the press conference, or you have to write officially to the judicial and say they should recuse themselves? You didn't have to go to social media, did you?
You see, that's what I'm saying. That when you're dealing with matters of this nature, you're dealing with the law and politics, and the law is mostly done in the courtroom, while the politicians do their politics wherever they are. This is not a matter that we could handle under the table, because this is a presidential election petition that we're talking about. Ugandans went out on the 14th in massive numbers and voted for a president who in our opinion is Kyagulanyi Robert. We believe he was massively voted by the people of Uganda.
On January 14th, what we have is that President Museveni beat your candidate by 2.5 million.
And that's what I'm saying.
2.4 million votes. We're not talking about 10,000 votes or 100,000 votes. We're talking about 2.4 million votes, Mr. Rubongoya.
But you are Ugandan and you saw what happened in this election. I mean, I'm even at loss to call it an election, but I mean, you saw what happened. It was conducted more or less as a military operation. You saw internet switched off completely, countrywide. The radio stations interrupted and ordered not to relay these results from other sources, except a few special stations which were allowed to carry some forms of results. You saw the levels of ballot stuffing that took place. You saw the levels of where military people were just going around.
But you know, all those things you're talking about, Louis, would have had an opportunity to see them. You would have exposed the system if you continued. In fact, you would have helped in expanding our democracy and jurisprudence.
But that is why we have gone out of the court, because we tried to file this evidence and the court rejected it. The court refused to give us an opportunity to file that evidence.
Let me go to Mr. Karemani. You speak for the judiciary. Yes. And when the Honorable Robert Kyagulanyi talked at a press conference about the 3 people he thought they should recuse themselves from the case, we had the Chief Justice respond to social media talk and press releases. I mean, that was irregular for a Chief Justice to respond to social media talk. Couldn't he have waited when they formally, you know, state what they needed to say before he could just jump in and speak like a politician?
Thank you very much, Patrick, and good evening, our viewers. You have to appreciate that the response for the Chief Justice was precipitated by the submission of the Land Attorney General, who raised it to the court, and therefore the court could not just ignore what he had raised. They had to answer him. So what response he gave was in response to what the Land Attorney General had raised. Now, going to...
But all these things, Mr. Karemani,
yes,
had not officially or formally reached his table, his desk. We expected him to, with honor, to respect his office and wait and respond appropriately, not to respond to social media, because even the Attorney General was responding to a press conference and responding to social media.
Very right.
He could have
yes,
he could have
yes,
done much better.
And I think
when he's accused of behaving like a politician, things like these.
And I think his response was
dent his image.
His response was limited to what the Attorney General had raised, and if you recall what he stated, he said, "Whatever transpires outside there will not have effect on what we are doing in the courtroom." Now, going to the issue of recusal. The issue of recusal being said at a press conference was caught. It is not taken to be an application for that, because it never came to the courtroom that anyone applied asking the 3 judges that were being portrayed in the media that they should recuse themselves. And for that matter, there is no way they could come out and say we are recusing ourselves.
Do you get a sense, Mr. Karemani?
A media portrayal.
Do you get a sense, Mr. Karemani, that almost every average Ugandan could predict with certainty the outcome of that court in terms of the petition, the result, the verdict?
At least I'm not among those that you are mentioning that would predict, because the moment you come to court, you are coming to court with evidence, and it is expected that you are going to wait for the court to come out with a verdict. If you come to the court with a predetermined decision, then you don't need to come there, because you know the results. So that's what we expected, that when you come to court, you are coming with evidence and allowing the court to decide on the matter. And that's what we had expected to take place. So the issues of recusal, at least the one that we have seen is one that concerned Mr. Maviris. That one was brought in a civilized way. It came to the floor of court, and the court listened to him.
But recusal happens. It has happened in other jurisprudences.
Yes.
And I think they have a point, because they are talking about somebody who is the Chief Justice, who was a minister in the cabinet. They are talking about somebody who was a personal secretary of the president. They are talking about somebody who is having meetings that are suspicious with the same person with whom they are battling out within court. They have a point, don't they?
Yes, but the question is, they have a point, and where have they raised it? That's the question I'm asking. Have they raised it in the courtroom and asked those people to recuse themselves? And they have ruled on it and said, we are not recusing ourselves. So it is not being said in the courtroom. And the procedure is very clear under the law, that if you feel you don't want someone to sit in your case, you come to the courtroom, you raise your grounds, and then the person examines what you have stated, and then the person makes a ruling on whether he's recusing himself or not. That is the law.
But you know that the Honorable Robert Kyagulanyi was voted by millions of people in this country on January 14th. What is being talked about the Chief Justice of our country is forever denting his image before the people of Uganda, and
Patrick,
raising an element of doubt about him.
Mr. Patrick, I wouldn't want to go into, for me, I speak the law, I don't speak politics. As to whether who was voted or not, I don't go that side. I'm talking about
this case was as much as legal and also as political. It was as political and legal.
It is, but when we come to the courtroom, we don't speak politics.
Yes, but
we speak the law.
Right now, there has been a clear divide. Those who are opposed to the system have put you in a certain corner. So by circumstances, you cannot avoid it. But let me go to Mr. Barata there. You are the NRM lawyer, and President Yoweri Museveni has been in power for 35 years. Technically, he has appointed every judicial official on the bench. If it was another country, perhaps you would have said after 45 years, many other presidents maybe have appointed. Really, that alone, makes this, it makes everybody feel jittery. Even if you are on the other side as a lawyer, I'm sure you'd raise that as a query.
Thank you, Patrick. Well, first, you are wrong. I wouldn't raise that as a query. I think I have...
you're still the other side, so you're still defending
I have sufficient professional training and understanding to gather what the situation is and to understand the situation. But let me also start by saying that when you go to court, you go to prove your case. You do not go to court to have court prove itself to you. You go to prove your case before court with evidence. So it is wrong to begin by saying that, oh, we were giving court a chance. No. You go to prove your case. So if you do not have a case, do not step in court. If you are not confident enough to argue your case, to present evidence, then please do not go to court.
How do you prove,
so that is the first
your case
that is the first
before judicial officials on the bench? Some of them
that is the first point.
who are seen to be biased.
The second point on bias. Bias, there is a way of dealing with bias. My colleague, my land friend, Mr. Rubongoya, who is also incidentally the Secretary General of the NUP, is a lawyer. He knows, I presume, the procedure for seeking recusal of a justice of any court. Did he take that procedure? Did he advise on that procedure? No. The petitioner is represented by senior colleagues who are my age even, but they did not take that course. So it is duplicitous to try and suggest that evidence was denied, or that you try. Even right now, the application itself, the application that is before court does not cite a lack of recusal or refusal to recuse as a reason for withdrawing. So it is duplicitous to come here and tell the public that court refused. I would also like to correct the impression. When you are beginning, you said court twice denied them opportunity to present evidence. That is also not correct. The correct position is that court found, and this is on record, you can go read it, court found it was not necessary to have an amendment. In fact, court said, except for one point where you are out of time, and that was where they were trying to say that President Museveni is not qualified to stand, which is in itself a ridiculous argument, because you are saying that once somebody has stood once, then they cannot stand again. We all know that not to be correct. But court said, except for that one, everything else is pleaded. Just put in your evidence. Did they put in the evidence? They didn't. So my point here is that from the get-go...
Are you saying they are bringing new ground, or maybe...
Yes, they tried. The one ground was rejected, and the rest court found that, no, you have pleaded these grounds, go ahead and bring your evidence. Now, from the get-go, the petitioner and his party have set themselves up in such a way that they believe that no rule, no law applies to them.
But look, the petitioner was incarcerated. The petitioner was incarcerated in his home after the election for almost 11 days. You have only 15 days within which to file a petition. He's the petitioner. He's supposed to be free, run about, looking for everything that he needed. Really, can't court understand that this man who has a grudge is at a disadvantage, where he has been put in that disadvantage by the state or by the incumbent president? 11 days out of 15, he cannot do what he wanted to do. Don't you get it?
Now, of course, the issue of his restriction in his home was determined by court, and the court made a finding on that area, and that is there. It is a given. Nonetheless,
well, I mean, doesn't that impact?
Let me explain.
Doesn't
this
that
to you.
impact on his petition?
It could.
It does.
It could probably impact on his petition, but did it?
Can't the court just
did not
realize that?
On 11th, when this matter first came up, by 11th, we had consumed 11 days since the filing of the petition, not since 16th. Just if you consider the period of time from 1st February when they filed the petition to 11th, those are 11 days. Not a single affidavit had been filed. Counsel comes to court for the petition and says, I have 50 affidavits today. I will give them to you. Today, 50. And he says, by Sunday, that was a Thursday, he says, by Monday, I will give you another 50. And those are substantially what the case is about. Court said, well, fair enough. You have your days. Put them in by 5 o'clock on Sunday. What happened? They did not present a single affidavit. A single affidavit. By their own statement, they said they had them. They did not present a single affidavit until 5 o'clock in the evening. 5 o'clock in the evening, and they even did not present sufficient copies of those 53 affidavits that they had presented. So it is duplicitous.
So the issue is copies?
No.
Or the issue is because if they have reached at the deadline of the time, that's okay. So your issue is they didn't give enough copies?
The issue is tardiness. The issue is sloppiness. And
but why do you give a time frame?
And that cannot.
Why do you give a time frame of 5 p.m. on a Sunday? And if they have made the deadline, so your issue is just having fewer copies?
There are time frames. No, that is not my issue. My issue is explaining to you that by their own statements, they are being duplicitous, because on one day they say this, on the next day they say the other. Today they are telling you now, oh, look at court, look at this and this, the previous decisions, because they have no real reason on which to stand to make their claims.
Louis, I mean, he's telling you actually lacked evidence. He had no evidence.
My learned brother is misinforming the public about several aspects. One, the Honorable Kyagulanyi, the whole country knows how many days he spent under house arrest. And certainly, you know, previously people used to have only 10 days. And maybe it is very clear if we still had that position, he would not even have been out of house arrest until after the time had elapsed. So thank God we had these 15 days, but the petitioner had only 4 days. And it is wrong for him to come here and say that did not affect the petitioner's case, because every time we've gone to court, this is what we've been pleading. The government forces and security operatives have arrested so many people, Even people who saw affidavits in our favor are being hunted down in Sinjiro. Some of them have been threatened and they have had to flee from their homes. We had people with DRA forms. We communicated with the country and we are on record. The police has not come out to deny all this. We've even written to all these agencies. The arrested people had our DRA forms. So these are the circumstances which you're operating under. From there, you file a petition. And we are looking at, he knows very well, he should know that there is something called the doctrine of precedent. And once courts have behaved in a certain manner previously, unless if there are very, very special circumstances which warrant the courts to move out from their previous conduct, they should stick to that. In the previous, for example, in the Amambawa's petition, many days later, the petitioner then presented an amended petition, and it was accepted. When Honorable Kyagulanyi was released from house arrest, we sat and hastily put together a petition and filed it under the impression that if we come up with other grounds, we'll certainly be able to file an amendment to our petition and it will be accepted. He is talking about the fact that there was only one ground which was different. But I'll tell him that that was a very, very substantive ground. He's trying to trivialize it, but that's not true. The Presidential Elections Act was amended in 2020 to provide that any person who is connected to the organization of an election is not qualified to run for president. And we raised that as a very, very strong ground, and we defended it. But the Supreme Court, in its wisdom, said that you cannot, denied us an opportunity to amend this. Then, about the filing of affidavits, he should know that in the previous decision, first of all, because this is supposed to be an inquiry, the election petition is supposed to be conducted as an inquiry. In the Besige cases, Dr. Chiza Besige cases of 2001, 2006, the court was very clear that evidence should be filed even throughout the hearing. And the reasons are clear. One, you're given a very, very short time within which to bring together all these affidavits. You're looking for witnesses from across the country, everywhere in this country. If you look at the affidavits we had, the ones we tried to file and these people rejected them, they are from the entire country, and we had many more. But as he knows, the process of putting this together, these affidavits, making sure that you arrange them properly and binding them, commissioning them, everything, it's such a tedious process. And we're talking about the fact that we went at 5 p.m., filed those which were there, and we had brought others. I mean, we thought that this was, because how can a Supreme Court want to decide a case without evidence when evidence has been presented to you? Okay, in the form of all these
Mr. Karemani, you know, many people, including him, are raising the case of 2016, the petition of Amama Mbabazi, where he was allowed to bring in evidence, you know, to keep on adding to what he had. And in 2016 it was okay, 2021 it is not. We don't get it.
Now, Mr. Kamar, one thing you have to notice that when you handle, there is what we call case management. Case management is you agree with the parties on how you want to flow in a case. On the 11th of February, the court sat, and the purpose of that sitting was to agree on the ground rules. They were supposed to conference and agree with the parties and the lawyers on how the case should flow. Now, they came up with what they put on the table and said, this is how we are going to handle this petition. The lawyers were all in attendance. Whichever lawyer was not comfortable with what was put on the table, it was expected that that lawyer should raise it, and it is handled there and then. But
so are you, Mr. Karemani, are you telling Ugandans that the NUP lawyers agreed to continue the case without the probability of them bringing in any evidence to supplement their
Yes,
petition?
they agreed and said
they have agreed that they won't bring more evidence?
We shall flow. They said, by this day, we expect you to have filed your affidavits. By this time, the other side should have filed their affidavits. If there are any affidavits in rejoinder, we expect them to be filed by this time. This time we shall come back to sit for purposes of doing ABCD.
So you're saying they never agreed on the amendment?
At that stage, it would have been expected that whoever was not comfortable with what was being agreed upon should have raised it and said, yes, my lords, you have said ABCD, but because of the following reasons, we feel you should adjust and give us a chance to do ABCD. But it becomes wrong for you to sit there, agree and say, yes, we are going to do what we have agreed. Then tomorrow you say, I was not given an opportunity. That means you are changing the goalposts and you want them to move the way you want.
Were those the rules of engagement?
Certainly, see, the reason why we have, why the law allows you, for example, to make this application for extension of time and all that, is because the law envisages these circumstances. First of all, it was wrong, very wrong in the first instance, for court to set a timeline as when you need to file in all affidavits, and to give us such a short time. They're talking about between Thursday and Sunday to be able to put all this evidence together, arrange it the way it is supposed to be arranged, you know, help the court guide them to where the authorities are and all that kind of thing. So what we are just saying was, okay, you said the court will be closed at 5 p.m. The lawyers, by his own admission, the Chief Justice saw some of the lawyers even coming on borders. They rushed to the court, tried to file this evidence, and you decide to close it out. Even when the law actually says that if someone files out of time, just note right there and say it is filed out of time. The Supreme Court did not give us a chance in that instance. And that came at a backdrop of us trying to file on a Saturday. We tried to file our petition initially on a Saturday, and the court said, no, we do not, the court registry will be closed on Saturday. The NRM lawyers went there, and it was open for them. I had them making an argument that actually, because in one instance you were filing for the first time, and then here the case had started. I will remind them that in 2016, the Honorable Mbabazi filed his case on a Sunday. So we just started sensing danger because we saw the double standards at play. And that is why we eventually said, this is not going anywhere.
But Mr. Kamara, if yes, I can come in there, the time time starts running when you have filed your petition, right? And by giving you an opportunity to file on a Monday, I would have expected that you have been given a chance now to go and collect more evidence. By the time you come on Monday, what you would have corrected on Saturday, you would have added by Monday, because you have been added more 2 days to do what you are supposed to do.
As I've said, there is a lot of duplicity and lies. And quite frankly, the petitioner and my colleagues here have no reason. And that's why they keep going back and forth, trying to catch things in the dark, finding a reason. There is nowhere where the first filing of the petition is an issue. The petition was filed. We responded within our 3 days. Then we had, between the filing of the petition and the first appearance in court, is 10 days. Nothing was filed. 10 days. Now, for you to keep going back, first of all, if you had just a little reading, you would know the rules. The rules are that when a date, when a deadline falls on a Sunday, then the next then the deadline is automatically extended to the next working day.
Now let me just come in.
Okay.
If I could just respond to that very quickly.
Okay, let him respond to this.
It takes just a little
Are you telling the nation that in your submissions you did not raise that as an issue? The NRM, the Attorney General, and the Electoral Commission all said that the petition was filed out of time. He is here now trying to say that, you know, it is okay to file on a Monday. But
did the court uphold that?
He is the one raising that. You see, he's the one raising that. He is a lawyer for one of the respondents.
The court never
Mr. Kamara, you see, for me, I can write what I want in my documents. I do not defend the petitioner's case. I do not prosecute the petitioner's case. But we have proceeded. Were I to raise that objection, it would have been raised on 11th February. It was not raised. And it takes just a little reading. Had you read a little bit more, had you prepared? So you cannot blame your lack of preparation. If I tell you that because a cow died in Mitiana, you cannot file this petition, you would have accepted and also gone with that?
But how can
so
you see?
You cannot blame a lack of reading or a lack of preparation on your side on the respondents. They are obligated to put up any defense that they see reasonable and fit.
And then once
And
you put it there, then you come here and say it was completely okay. You run off from, you move off from your...
I am telling you that you are finding excuses where you shouldn't. You should have raised that at the first day on 11th. Now you wait. You have gone through processes, gone through
I don't know why you keep saying that he shouldn't go back to some things, because whatever happened even before filing of this petition,
yes,
will impact on their quest to look for justice.
Let's say the impact.
Yeah, it does, because you actually left them with only...
Let's say, Mr. Kamara, let me agree with you that they impact. Let me agree with you that they impact. This ground he's talking about that court rejected, the one about qualifications of the president, how, you tell me, how is it impacted by anything? The president was the president in 2016, the president was the president before 2016. How is that impacted by events?
We are talking about
16th February 2020.
But we are talking about a presidential amendment of 2020.
No, but when was the amendment made?
It was in 2020. That's what I'm telling you.
And you didn't know that the amendment was made.
You
so that, how is the incarceration or restriction of the movement of the petitioner? How does that affect the knowledge?
You really think that when somebody who is incarcerated, it doesn't take away his freedom to do, even to think, and even to strategize?
No, Mr. Kamara.
You think incarceration does not...
No, Mr. Kamara,
is not a hindrance?
I have been seeing them saying some of our witnesses are in prison. We take evidence from prisons all the time. There is somebody called the Justice of the Peace.
Yeah, but
there
are so many ungazetted places of detention.
Wait, that is number one.
Maybe they are only known to you.
Now, Mr. Kamara,
yes,
it would be foolhardy for me as counsel to claim you as my witness before I've interviewed you.
So let me...
It is completely foolhardy, and you
but,
can't blame
but,
that on
but
anybody.
you also know that
yes,
there are quite a number of ungazetted places of detention.
No, I don't.
Yeah, but, well, people have complained that their people have been abducted, taken by the state. They don't know even where they are. So if you say that they are in prison, perhaps you know where they are. But
they know where they are. They have said they are in prison.
You know, I would really want that when we come here, we first of all take these matters very seriously. Because they are very serious matters. We're talking about people's lives. We're talking about countless citizens who are abducted. We're talking about young people who have resurfaced with wounds everywhere, with broken limbs. So let's not come here and try to bastardize these issues and try to trivialize them. I really take strong exception to that.
No, these are very serious matters. These are very serious matters.
When he says that you can go to prison and access people there, I'll tell him that for me to be able to access our people who are incarcerated at Chitalia, you do not know the hardships we went through. We were eventually allowed, you see the deadline was on a Sunday, we were eventually allowed to see them on Sunday. I personally went to Chitalia on Sunday. I was only able to interview 2 out of about 30 people that we intended to interview, because we were only given access, and we were given only 2 people access to see these people, and the hardships of getting clearance to go to Chitalia to be able to interview these people. So when he says that, you can go and interview people, it's really unfortunate.
Mr. Karemani, listening to him, the hardships they go through, they have gone through, do you take those into consideration as court?
And Mr. Kamara, I think all these were brought to the attention of court. They were raised at the floor of court. And like I said, when they were raised, court of course took cognizance of those facts. I remember I was personally in that courtroom. I remember what the Honorable Chief Justice said. But despite all that, the petition is on the table. And we have 45 days within which to dispose it. That's why they came up and gave a roadmap on how it should be handled. Like I have stated, if there was any issue of difficulties in complying, it would have been expected to be raised by the lawyers at that stage. And then the court would have adjusted. Now, the other issue of court rejecting the affidavits. I attended the court when they were raising those issues about the affidavits which were brought. It was considered that on the day which had been set, those affidavits were not there. The affidavits were not there at the time when they were supposed to be filed. By the close of the time, they were not there. They received what was there, which was 53, and the other extra were not there. Now, the extra were brought on another day. Remember, the timelines were set by a panel of 9 judges. The setting of the timelines is an order. It's an order of court. The court sat and made an order that this is how we are going to proceed. Now, for the registrar to sit down and say, I am going to change the order of the 9 justices and you just bring them. That would be very wrong.
Okay.
And that's why she advised them, please, you have to go to the floor of the 9 judges who set the order and convince them to change it.
Gentlemen.
So she was right to do what she did.
Gentlemen, hold on to your points because we're going to take a break, and on the spot, we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guests tonight are Jameson Karemani, Judiciary Spokesperson, Rubongoya, NUP Secretary General, and Enoch Barata, an NRM Lawyer. And we're talking about the withdrawal of the presidential petition by the Honorable Robert Kyagulanyi. I just wanted, the truth is, if this petition, in my view, had continued, Mr. Barata, it would have given the president 2 things. One is the legitimacy that has come from the election, but also the legitimacy that is coming through the judiciary. But now, by them, withdrawing that, it's a smart political move that has denied your client the judicial legitimacy.
Yes, Mr. Kamara, you see, legitimacy is a matter of law. I see people talking about legitimacy. Legitimacy is a matter of law. And President Museveni was legitimately and validly elected by over 5 million people. That is 50-something% of the cast vote. So there is absolute legitimacy, and it is not necessarily validated or invalidated by a court petition, especially unless court has.
Yeah, but you see, when you get that legitimacy from the people, and you also get it from the temple of justice, that becomes that's the second win. He hasn't. Yes, he has not gotten it. In fact, he has not gotten it.
I will put it to you. I will put it to you that even now we have a win. Even now we have a win because council has. The petitioner has clearly conceded that he has no basis on this matter and is withdrawing. So that's not a problem. But the point is that the president is validly and legitimately elected. So you might want to play, and yes, I understand what you are saying, which is correct, that this whole thing is a gimmick to play a political game, a political maneuver. But well, I am a lawyer, and that is not my area.
Because
but I do agree that indeed the petition is making a
the Honorable Robert
gimmick.
Kyagulanyi had stayed with this petition, and probably the court finds his grounds are not fundamental enough to change the status quo, that would have given the NRM and your candidate, settled almost everything. It would have settled the scores and move on. But now, it leaves a bitter taste.
No, it does not at all. It does not at all. We are quite confident, and as you can see, we responded. In fact, perhaps maybe what you are saying is that we will not have a chance to present our evidence also. But some of it, fortunately, was covered by the press, like the forgeries, like the false affidavits that are being sworn, like all these things, they are there. And with time, we shall be able to unfold them. But unfortunately, we can't go too much into those because there is still an outstanding matter. Nonetheless, for us, we contend, and it is a matter of fact and a matter of law, that the president was validly and legitimately elected.
So, Jameson, they raised an issue of the Chief Justice in meetings that can be characterized as unbecoming or suspicious with the president, especially at the time when the petition is ongoing. All of you, I suppose, you're lawyers. And you have a saying that justice should not only be done, but should also be seen to be done. So when you see one of the respondent, the Chief Justice, and the Chief Justice is asking for a budget, is asking for these things, couldn't he have waited to dispose of this petition. And then you can present your demands. After all, actually, demands should have gone through Parliament, and then it's the Parliament that appropriates money.
Now, thank you very much, Patrick. One thing we have got to notice that with politics in play, elections and the rest, there are things which must be done, which are constitutional. The issue of the budget, according to the Judicial Administration Act, which was passed in 2020, that budget is supposed to be presented by the Chief Justice to the President by law. And then it is the President who is supposed to forward it to the Parliament. And mind you, without any change on what has been presented. He only puts his notice, some notes to accompany the budget to the Parliament for appropriation. Now, we are in a budget cycle. Timelines are running. This is February. By June, the budget should be having the budget being read.
Yes, but
so
I can understand what is at your legal altar.
Yes.
But I'm looking at the practicability of it. Does it really make sense that the Chief Judge of Uganda, Chief Justice of Uganda, is going before a respondent in a case to ask for money and ask for more judicial officials? Yet he could really have waited to dispose of this case because, as you say, justice should not only be done, but should be seen to be done. In this case, it cannot be seen to be done.
Now, that's why I'm saying that you must look at the background and the timelines that are given by the law. Presentation of the budget, you wait until the budget is read without your budget incorporated. That cannot happen. That's why we come out to explain, which have been missing. Many people have not explained all these things. They think that the Chief Justice had gone to request for the money. He is presenting a budget which is under the law. The law was passed by the Parliament, where they say it is the Chief Justice who must present that budget to the President, and their timelines. And the other issue is that some of these things that have to be done, they have to be done because the Constitution stipulates so. The Constitution stipulates so. The President remains the President by the law. Okay. And so, the Chief Justice has presented the budget to the same person.
So,
and that interaction of presenting the budget, I don't see any...
Incidentally, that budget process, I think, has to have ended by March.
Yes.
Mr. Rubongoya,
the practicality
one of the issues, I don't know whether you raised it as a complaint or you're going to say it, or you put it formally, was the President meeting the Chief Justice. And clearly, the President is an incumbent President. So if a President cannot meet the Chief Justice of a country, how can a country move on?
Well, if you would permit me to first of all respond to my learned friend Enoch, who seems to suggest that talk about legitimacy, the President is validly elected. I want to remind him that he's here representing a man who went to the bush because there was a rigged election in this country. The people at the time who were in power here in Kampala were calling themselves legitimate, the same way you're talking about legitimacy. So I don't want you to just think of legitimacy as, Mr. Byabakama declaring that this person has won with so many million votes. The person you're representing went to the bush against a rigged election, meaning that what you're talking about, the population, Uganda is not full of people who cannot see. They know what kind of election they went for, and that is why we've said we're taking this matter back to the court of the people. Now, away from that, when again the spokesperson of the judiciary says that the Chief Justice had to meet the President. In other countries where the judiciary is independent, a judicial officer would be very, very careful, would be extremely careful, because indeed, as you said, justice must not only be done, but must be seen to be done. I watched what happened at the opening of the lawyer, and the President was there. He responded in a matter of this magnitude. And the Chief Justice was there telling him, I want you to give me more magistrates, give us more judges, Mr. President, give us this and this. Things which, of course, are supposed to be done in the next year and that kind of thing. What the population which is seeing? First of all, the president has not been his habit to attend this particular function, the opening of the law year. They could have invited any other person to be a guest of honor at that event because of the sensitivity of the matter. When he talks about, for example, the administration of the Judiciary Act and all that, the Chief Justice has a Deputy Chief Justice, and there are other officers who could go and do any obligation given to them by the law. It is not, I mean, a judicial officer must be very careful when we are being told about the law, even at lower levels of judicial officers like magistrates. A judicial officer must be very careful about the perception. How does the population perceive you? When, I mean, for the Chief Justice to be able to give confidence to the people, he could certainly not engage in some of these meetings in the way they did and the words which were spoken. But, of course, you don't just look at the meetings. You look at the other conduct like we've been talking about. You look at the antecedents. Of course, although we did not wait until we could file an application for recusal after we saw the way they were behaving. But another person went to the same court and said, Chief Justice, recuse yourself. And you saw the reasons which he gave for not recusing. So, and certainly that would have been the same situation.
Patrick, there
if we had gone.
stop there. We shouldn't go there because they have not given the reasons.
Yeah,
the reasons are yet to come. So if we go into that area, we are entering into
not formally, but actually what the Chief Justice said. I mean, the comments, the comments he made.
Let's wait for the ruling in that matter so that we don't subjudice whatever is going to come out of that.
But the issue of legitimacy, Mr. Barata, that you think your candidate has, that legitimacy has come, but you should remember, on November 18th, 50 people or more were killed on the streets of Kampala. You should remember many people were killed. You should remember that many people were abducted and are still incarcerated in places that are not officially gazetted places of detention. I mean, is that the legitimacy you're talking about?
Now, let me begin with that.
When it is supported with all those, really, I wonder what you mean by legitimacy.
Let me begin with that particular event you are talking about, 18th, 19th November. There were riots, and let's not be shy about it. There were riots, there was complete chaos. There had to be a restoration of order. Now, it is most unfortunate, it is very sad that citizens of Uganda lost their lives in those riots. But there must be no excuse for inciting violence. There must be no excuse for inciting insurrection. That must be made very
but
clear.
The president
now,
said,
let me finish.
There are some innocent people.
Yes, and it is very unfortunate. By the way, even the ones who are not innocent, even the ones who are not innocent, it is unfortunate that they lost their lives.
You see, if there were innocent lives that were lost or were killed, somebody shooting them dead, and no one has been punished for that.
Let me answer.
Is there anybody who was paid for those crimes?
Just let me answer. So first of all, it is unfortunate whether they were rioters or not. It is unfortunate they lost their lives. But there is no excuse for insurrection. But secondly, we are talking about legitimacy. If we are talking about legitimacy, this election, and my land friend has argued quite accurately, it is a process. The process has shown from youth elections, from councillor elections, from MP elections, it is consistent. There is a popular legitimacy of the president. And you cannot deny it.
You are an office of court.
And you cannot deny it. So that is just statistics.
Innocent Ugandans were murdered in cold blood. Has anybody been punished for that?
I am not aware of whether
you are an NRM lawyer.
I am an NRM lawyer. I am not a state lawyer. I am an NRM lawyer. I am not a state lawyer, so I do not do investigations on the state. I do not work for the police. So, but nonetheless, I am aware that there was an investigation ordered. That I am aware of, generally speaking. What the outcome is at the moment, I don't know. But there was an investigation, and I am supportive of an investigation
on
that.
No one has been punished.
Unfortunately, then you are wrong.
I put it to you that no one has been punished.
You are wrong in that respect, Patrick.
And the Ugandans are questioning why. Yes. You have now the European Union Parliament condemning this election. You have the State Department condemning what has happened.
I don't
In
think.
fact, you have the world
I
doubting
think,
the legitimacy you're talking about.
I think you are operating on rumors, Mr. Kamara.
No.
State Department has not condemned anything. There was a question answered at a press conference by a member of the State Department. That is not a statement of the State Department of the US.
State Department.
It is to overstretch the matter.
If Mr. Karemani is speaking for the judiciary, why would you doubt?
It is to overstretch the matter. Now, there are many people involved, and everybody has a right to express an opinion one way or the other. Now, unfortunately, we must stick within the law, because if we go all directions, then we'll never get anywhere. But unfortunately, this is where we want to be taken. We want to say, let us set aside the rules. Let us not follow the rules of court.
Mr.
Let us not follow the rules of petitions. Let us do things as we please.
About the issue of the judicial legitimacy that has been that you have been denied. That
we have not.
That your client has been denied.
We actually have not been.
That's why I'm showing you that people in Uganda are doubting the legitimacy, and so are people elsewhere in the world. And
I don't think
we're still within the discussion.
I don't think that we have been denied, or the respondent for that matter has been denied judicial legitimacy.
Let me ask my producer to play that clip from the State Department, perhaps once more. Can I have it?
From the press conference, you mean?
But he represents the State Department.
Yes.
If you can get it.
Uganda's January 14th elections were marred by election irregularities and abuses by the government's security services against opposition candidates and members of civil society. We strongly urge independent, credible, impartial, and thorough investigations into these incidents.
There is no provision in our constitution or in our laws which says the elections of Uganda will be credible only if Americans or Europeans or foreigners have witnessed and sanctioned them as credible. 3, we primarily run the government for the interest of Ugandans, and so Ugandans are our primary constituent.
Okay, I think that's a good thing that my producer tried even to balance it. I was worried that he was only going to play the State Department without Mr. Ofonopondo. You can clearly see, okay, forget about whether he's speaking for, I mean, the things he's talking about are things that happened.
And they're being investigated, Mr. Kamara. And some of them, by the way, have been answered in the petition. Unfortunately, as I said, we can't get into them because the matter is before court. But we will have a chance, perhaps, once court has done its job, we'll have a chance then to address those matters. But
do you see slowly that Uganda is more or less going to be referred to like a pariah state? We are almost now a Myanmar or North Korea of sorts.
Sorry? I think that would be to stretch it. That would be to take us into a different area. But no, I wouldn't agree with you.
Yeah, but in Myanmar, 1 or 2 people were killed. In Kampala, 50 were killed officially.
I am not familiar. You can give me the story about Myanmar, but I'm not familiar with this.
But you see that the world is pointing fingers at us. When a representative of the State Department says what he has said to the world, you, as a lawyer representing a party that is in power, that should concern you. Now,
in the USA the other day, they were trying President Trump for what was termed as an attempted coup, for him just demanding an audit. And they clearly stated that was an insurrection. An attack of that nature was an insurrection. Now, here you are trying to justify insurrection in Uganda, insurrection. We must deal with our problems.
Whether it is done in the Capitol Hill or here or in Kampala,
we must deal with it.
It should be condemned, whether it is there or here.
It must be condemned.
I thought you would condemn both of them.
I am condemning any riotous acts. I am condemning violence. I am condemning a lack of respect of the law and order by whoever it might be.
So when you say, Mr. Rubongoya, that now you want to go to the court of the people, exactly what do you mean?
Well, what, of course, Mr. Barata is depicting here is the typical nature of the NRM, insensitive, living in denial, really not concerned. I would expect him at the very least to condemn the excessive use of force by security agencies, disproportionate force, including the use of what the state called, stray bullets that ended the lives of the citizens of this country. And of course, although the figures were put at 54, we believe that many more people died under those circumstances. And I also want to disagree that people were killed, were rioting. I mean, very, very many people who are not even involved in these events at all were shot dead, who are just going about their business. But he probably should also address us on the people we saw, with some of them putting on sandals and, as if someone just moves out of the bathroom with a gun and starts shooting people. Is that the state he really, really wants to live in? Does that require someone to first go to court? Does that require someone to first do investigations? Isn't it logical to anyone, let alone a lawyer, that people who should hold arms should be identifiable, should be, citizens should be able to know this person belongs to this agency and that kind of thing. Why are we saying that we're taking back this matter to the court of the people? Chapter 1 of the Constitution of our country talks about sovereignty of the people, and Article 1 therein says that all power belongs to the people. And so we are saying that, first of all, we have tried all these other legal avenues within the constitutional framework. We've gone to the Electoral Commission, we've tried Parliament, we've gone to the Supreme Court, and because, and I think you raised a very, very fundamental point, the problem of this country is, of course, overstaying in power by one leader. That right now, we have a judiciary which is entirely appointed by one person. I do not blame the framers of our constitution for example, saying that the president, with the approval of Parliament, should appoint judicial officers, judges. But it was also expected that that would be done in the context of presidential term limits, such that a president has an opportunity to appoint a number of judges, and then another one who comes appoints others, such that by the time at any one point you would have a mixed bench with judicial officers appointed by different people. President Museveni is on record saying that he was going to begin appointing cadre judges because he was being frustrated by the judges who were there at the time. So you find that now institutions are under capture. If state institutions are under capture, what do? You're left with the last court of appeal,
but also,
and that is the people of
Uganda. But we have examples of people who have been appointed by the president, including Justice Kanyahamba, who has worked as a minister in the government. But in most cases, he has given, his rulings that are against the president. So it's not entirely true that if you are appointed by the president, you'll be giving rulings only for him, because there are examples.
That is why we have, for example, clearly indicated that we are not attacking the judiciary en masse. We are not actually criticizing the judiciary en masse, because we believe that there are some judicial officers, both at the lower levels, even on the highest court, even on the Supreme Court. I must say that I believe at the Supreme Court level, there are justices who do not approve of the conduct of the Honorable the Chief Justice in this matter. I'm sure deep inside their hearts, there are judicial officers who believe that this is improper, this is judicial impropriety. So we know that, and indeed, we know from history that Benedicto Chiwanika was appointed by Idi Amin to be a Chief Justice of this country, and he turned around and killed him because he was standing on his principles. So it is also not that we are saying that all judicial officers have a problem with them. There are some judicial officers, and that is why we've not given up going to court. You've seen us go there continuously. Even when the Musevenis were in the bush, there were some judicial officers. Although Museveni, in his President Museveni, or General Museveni as we prefer to call him, although on record so many times he was castigating the judiciary at the time for what it was like, for being compromised and all that, there are still cases at the time which were able to be decided in the favor of the people, and which some of the judicial of the decisions at the time we still use them as precedents. Even in classrooms when we are teaching law students, we use some of the precedents that came from the Amin era. So we are not saying that every judicial officer or that the entire judiciary is full of cadre judges. No, there are some judicial officers who have been appointed, and they say, okay, yes, you've appointed me, but I will stand by the truth. what has happened to those judicial officers? Most of them will not be promoted. Most of them, and you've given an example of Justice Kanyamba. He's on record talking about how many opportunities he missed from the time he decided to stand his ground and be independent in his rulings and decisions.
You know, the
I think
judiciary
Patrick
is in the dock.
Patrick, I need to correct one thing here, because when you say that some justices in the Supreme Court, some of them, when they sit there, they think that whatever was going on, they don't agree with it. That one I don't agree, because whatever communication the Chief Justice gives in that court is a communication of court. It's not his decision as the Chief Justice. That's why it is called a panel, and the Chief Justice is like a person chairing the panel. So when he's communicating a decision of court. That's why you saw in some cases the rulings were being read by some other justices other than himself. So we cannot say that the Chief Justice, you'd rather say the Supreme Court. I would agree if you take it as a court, but not segregating and looking at one individual.
Well, I would invite you to read Justice Kanyahamba's book, you know, the Joys and Blessings of Being Who You Are, when he was talking about the 2006 petition and the dynamics at play. And in fact, he castigates some of the judicial officers who were sitting on the same bench with him, including the Chief Justice at the time, for being compromised and intimidated last minute. He says that, you know, they had actually agreed to annul the election, the presidential election, and until calls started coming in, intimidating them and that kind of thing. So this whole idea of trying to say, oh, one judicial officer cannot be, that is why, for example, the proceedings of recusal, you can go for a specific judicial officer, and you say, this is the judicial officer I think is biased. Okay. That is why we did not talk about the 9 justices, because we thought that many of them are firm people, but the head of the court has a strong voice in terms of what happens.
Mr. Patrick, where did they go for him? In which court did they go for the Chief Justice saying he's biased? Did they raise it in the court, or they? Because you have to give him also an opportunity to be heard.
Well, someone did actually, no? And he declined.
No, we are talking about you. Don't use the other one.
Okay,
as the case now.
but even then,
you use you know, what, you don't use
like I said,
which is also pending a ruling.
Yes. Like I said,
yes.
No, he actually said he was not recusing himself. So
he's going to give the reasons. So we don't want
to give the reasons, but the ruling has been there, because the ruling he has said,
you know,
it is well known. But just to respond to him very quickly on that. You know, we intended, when we made an application for filing additional evidence, we made it clear. We had a press conference and said, we are going to file this application. It is hard and determined. After that, we are going to file another application to request 3 justices to recuse themselves.
And, Mr. Kamara, I also want to correct this. At what stage do you ask the panel to recuse itself? Because at that stage, they have started handling the matter. I would have expected on the first sitting of court, when they came the first day, when they were laying the ground rules, but for people to come out and say... I
thought that was determined by the prevailing circumstances.
I would have expected them to raise it and start another panel is constituted.
Okay, gentlemen, we are going to take a break. And when we come back, I'll open the lines so that you two at home can be a part of this discussion. You're going to see the numbers on the screen. You pick your phone and call us, and please make it precise and concise. And should you be having any disagreements with any of the panelists here, you can disagree with respect. We'll be right back. Welcome back to On the Spot. My name is Patrick Kamara. My guests tonight are Jameson Karemani, Judiciary Spokesperson, Rubongoya, Secretary General of the National Unity Platform, and Mr. Enoch Barata, is the NRM Lawyer. And this is the moment when you get to speak. The numbers are on your screen. You pick your phone and call us, and please make it very brief. You tell us where you are from, where you are, your name and where you are, and perhaps if you have a question you want to direct it to any particular panelist here, say out the name so that we know whom you want to answer your question. So, moving forward, I have a call line. Hello.
Hello.
Yes, sir. I'm sorry.
okujjayo omusango gwo mu kkooti tetulina gye tubabanja nga bannayuganda abambuleera kimu mwakikoze obululu twabalonda ensi yonna yabalonda ne movement nebukwata nekyakyeŋŋamba abalooya abali aba movement banoonya mulimu we bajjeeyo omusango bategedde tebakyalina muki mulimu balooya ba movement kyesinga okwebaza pulezidenti waffe kujjayo musango kubanga ffe buli kimu bobi tetulina kye tumubanja.
Okay, thank you very much. I hope you understand all these things. I do also, so you'll be able to respond appropriately. Hello. Have a call. Hello.
Good evening, Kamara. How are you?
I'm fine, thank you. Who is this we're talking to?
Yes, I am called Richard and
Richard, your line is not very good one.
Am I clear now?
Yes, you are.
Okay. I'm called Richard Nyombi Biemaro.
Okay.
First of all, I would like to congratulate my Secretary General, Rubongoya, and our presidential candidate, that's His Excellency Bobi Wine, for having successfully passed through the electoral process, the electoral season, and went ahead to file a petition, which is now the talk of the nation. I think the case was already predetermined in the first place. First of all, the state itself, as usual, NRM, went after our polling agents by arresting them and confiscating our DR form. Now, those two NRM gentlemen, however much myself and my comrade Lewis, we have been in NRM, we know how they act. We know what they do after the elections. How do those two gentlemen think that NUP would have gathered evidence, yet all our agents have been arrested? Secondly, a lot of people are rotting away in Italy and other different prisons. Reason? They were arrested because they had evidence. They had evidence they could have played a key role in this election petition. They have not been given chance. They are rotting away in the prisons. For that case, the case was already predetermined. I congratulate the entire legal team for having seen that, and we withdrew. Yes, we couldn't proceed with such a case where the Supreme Judge himself showed bias of the highest kind. Okay, thank you very much.
Mr. Biemaro, you've made your point. Thank you so much. Okay, I think that's the issue I was raising earlier, that appears Ugandans, average Ugandans, could predict with almost a certainty what was likely to be the outcome of the court. Well, he does not represent all Ugandans, but a certain issue I raised. I have a call online. Hello.
Hello.
Yes. I have a call online. Hello.
Yes, Dr. Kamara, good evening.
Oh no, I'm still working on that PhD. I'm here to be a doctor. What's your name, sir?
My name is Dr. Derek, and I'm calling from Mengo Hospital.
Okay, Dr. Derek, you're on air, sir.
Thank you very much for the program.
You're welcome.
Yeah, I would like to begin by thanking all the panelists and thanking you for this program.
Thank you, sir.
Yeah, I thank Mr. Lewis Rubongoya for his submission. And I would like to just talk to Mr. Barata.
Okay.
That, you people in NRM play a lot of gymnastics on the lives of Uganda. And we have a whole country here at stake. Many people have lost lives, and people can think you can come here to speak a lot of English and play around a lot of things. But this country is watching, and it's full of stupid people. I just want to tell you that it is our country, and I thank Dr. Mr. Kyagulanyi for what they have done. Sure, there is no confidence in that court, and me, I concur with the decision of withdrawing that case of the court, because it was surely a biased thing, and we don't agree with it as the people of Uganda. And surely, like the principal has always said, at the end of the day, Ugandans have the last part, the way they are governed. Because at the end of the day, they are the ones who go to hospitals which do not have medicine, the bad roads, the poor schools, and the lawless streets around the country. Thank you very much, and God bless you.
Thank you, Dr. Derek calling in from Mengo. Thank you so much. Let me take a couple more callers so that if you have a question, please have a call online. Hello.
Yes, hello, sir.
Good evening. What's your name?
Mr. Kama, this is Gideon, sir, from Nigeria.
Gideon, Nigeria, you're on air.
Yeah, now, I thank you for the program.
You're welcome.
Actually, it's my first time to call on TV, and I'm so glad that I've called on TV on the spot. Now, my question goes to Mr. Barata.
Okay.
Actually, Mr. Barata, you're using a lot of English to explain nothing. Now you know that the state is playing from the security organization, the judiciary, the defendant. So if you think that we are stupid, sitting here, and you think you're coming here to submit your semantics and write Ugandan, that's a lie. Actually, there's a common thing that says that if Kangaroo Court was the person, that is the Supreme Court. So please, we have no confidence in your court and your semantics. Ugandan are tired, and we are watching everything.
Okay. Thank you so much. Each one of you, you keep saying you're watching. What is that supposed to mean? Let me let me pick another caller, man. Hello. Hello. I have a caller online who doesn't want to talk. Hello. Oh, sorry about that. You could try again. We had a comms challenge with that caller there, so we'll have to pick another caller. I'm going to pick maybe two more before. Yes, we have a caller. Hello.
Good evening.
Good evening, sir.
Thank you for the program.
What's your name? Where are you calling from?
Sam Kiwatule.
Sam in Kiwatule. Go right ahead, sir.
Yes. My question goes to Barata.
Okay.
Did he watch how the election events went, or he never passed? Sometimes we need to speak the truth. Forget about money and defending cases. If you watch how elections went, people campaigning with the bulletproof Kalangala, a leader is abducted, his followers are arrested, they are nowhere, and then you say they committed a crime. Why not take even their lead? And then also, in addition to that, if Kyagulanyi, who leads those, in fact, police up to now has failed to produce a list of missing people. Assuming some of those missing people are the people who were to swear those affidavits, where do you expect them to get those people? They don't know where they are. Thank you.
Thank you so much, our caller. I think you said Sam from Kiwatule. I want to take only two more calls, and then we'll close that. Hello.
Hello.
Good evening, sir.
Good evening. How are you, sir?
I'm fine. What's your name and where are you calling from?
I am calling from Kamngenge.
Yes.
I'm called Bachenga Stephen.
All right. Bachenga Stephen.
Hello?
Go right ahead, sir.
Hello.
Mr. Bachenga Stephen, you are on air. Please go right ahead with your comment or question. Oh, sad. We have lost that line to Kamwenge for Mr. Bachenga Stephen. Let me take the last caller. Hello.
Hello, come out.
Yes, sir. What's your name?
I'm
sorry. Oh, we have another comms challenge. And for that matter, I understand my producer is telling me quite a number of you would want to participate in this, and he's telling me I should take just one more. Hello? Hello? Unfortunately, that one is trying to listen to himself at the same time to talk, so it is sending an echo into the studio. We can't have a healthy communication. When you call, it's always better you turn down. You turn down the volume of your TV, and then it will give us a better communication. It won't send an echo where you are, and it won't send an echo to where we are and those who are listening. But I've closed the lines right now. And so, Mr. Barata, you have most of the questions, and Mr. Rubongoya, you have most of the...
Maybe I have one which I need to clarify.
Okay,
Someone
this is
said,
how we're going to go.
Someone said the NRM lawyers.
Okay. We are going to go like this.
That is what Ugandans are saying.
From Mr. Barata, and then we'll conclude like this.
Now, thank you very much. Let me begin with, I don't know, the first one was not quite a question, but let me try and respond as best as I can. There is this question in law that if you consider the laws to be a forest and you are chasing the devil and you cut down all the trees in the forest while you are chasing the devil, what happens if the devil should reach the other end and turn against you? Where do you hide when you have cut everything? So when we stand here to talk about the law, it is not English, it is not mere gymnastics. We live by the law. That is why we call it law and order. The moment you take away the law, then you have descended into anarchy. Anarchy is to nobody's advantage. Anarchy does not bring progress. So
the people of Uganda are your forest.
Yes.
You have disappointed them so much.
The laws,
where will you turn to?
the laws, Mr. Kamara,
Yes.
are my forest.
Okay.
The laws are my forest. So it is not mere English. And we must not think about it. It is not mere English, it is not gymnastics. It is the law. And we must follow the rules. Now, what has been consistent about the petitioner's manner of conduct is that no law and no rule must apply to him at all. And when you bring anything, it is consistent that he will blame. He will say, oh, this TV now refused to say what I wanted. So it is wrong because it covered the wrong thing. These religious leaders, they are not talking about me, so they are wrong. Now the judges, they appear to be telling me to follow rules. They should never tell me to follow rules, so they are wrong, they are biased. That is wrong. The law is paramount. If we are talking about governance, if we are talking about good governance, we must talk about the law. We cannot talk about good governance without talking about the law. Now, did I watch what happened? Yes, I watched what happened. And if you ask me my opinion, I have just told you what my opinion is. I watched what happened. And I can tell you, if I had a chance, when I get the chance, after court has disposed of the matter, I will be able to even present you evidence. But now, unfortunately, it is before court and I can't get into it. Right? So, but yes, I did watch, and I am telling you things from both my personal experience and from my own knowledge as a lawyer on this particular case. I have read, I have understood what's going on. Now, about court, there's a lot of attack on court. There's a kangaroo court, there's a kangaroo court. Let us remember that court deals with so many matters, criminal matters, commercial matters, land matters, family matters, all these matters. So this idea that court all of a sudden cannot manage to deal with things because of one case that comes once every 5 years, to which, as a matter of fact, court has extended every possible leverage. Court gave itself up to the last day, did not save itself any time, and still they have not complied. We have had lies on oath by counsel for the petitioner. They are there on record, they are conceded. We have had lies at the bar when you say you have affidavits to file on that day and they give you even more time and you do not even bring those ones which you said you had on that day. We have had a complete refusal to abide by the law. That is the consistent issue. Now, of course, I understand that you want to say you will defy. But the law is the law, and you cannot hide anywhere except within the law. So, anybody who tells you that now let's abandon the law and just go about what we want to do, that I can promise you is a wrong leader. That is a wrong person, is leading you to danger.
Okay, Mr. Karemani,
mine was just to correct one of the callers who said the NRM lawyers. I don't belong to NRM, or I don't belong to any party. I belong to judiciary and I speak for judiciary. As my concluding remark, yes, the petition has come to court. The petition is being withdrawn, and the framers of the law anticipated that at one time someone may bring a petition and that person may withdraw it. That's why they put that provision that you can bring your petition and this is how you can withdraw it. So to us, it is a normal procedure because it is the law. The law provides for it, and it has been done under the law.
All right.
So that's it.
Thank you so much, Louis. Your parting shot.
You know, first of all, listening to the people I've called in, the people on this panel need to understand and to listen, maybe to reflect, and the people who are watching us, especially on the other side of things. What I hear from those calls is a clear disconnect from the likes of Barata, from the common citizen of Uganda. They come here and sing the law, the law. Apartheid was legal in South Africa. The Holocaust was legal, and whatever the Hitler regime was legal in Germany. When you come here and start singing the law, you forget that citizens are actually watching. The reason why we go to school, and especially for us lawyers, is not just to say this is what the law says. It is to question the law. What is the import of the law? What is the purpose of the law? What is the objective of this law? And how does this law serve the ends of justice? Now, so the people can come here and say and sing about the law, but what you hear the citizens of Uganda say, and when they say we are watching, that should not be taken lightly. And he was talking about anarchy. How do you prevent anarchy? Let justice flow like a river. Let there be justice. And let the citizens of this country see that the judicial officers are exercising their function in a manner that is fair, that is equitable, that is right to all manner of people. So, for me, as my parting shot, I'll encourage the people of Uganda to continue struggling for their democratic rights in this country, to say that it is upon us, and this is not really about NUP, it's not about the Honorable Robert Kyagulanyi. I was very happy somebody called from Mengo and talked about the conditions there. I mean, for me, it's to encourage the people of Uganda to continue struggling until this country sees a new Uganda where all citizens can live in dignity.
Mr. Louis Rubongoya, Jameson Karemani, and Mr. Enoch Barata, I want to thank you so much for your time, but most importantly, for your insights on this issue. I want to thank all of you who have been a part of this discussion. I want to thank you for your great company. I know Uganda were good people. We're a good country. We mean well. The political divide is just because everybody is trying to present their version of what they think can take Uganda to a better position. It's a good thing that when people are aggrieved, they go to court. In some cases, people can pick AK-47 and go to the bush or even kill. So now that they have withdrawn the case, and maybe they're saying they're coming back to you, the people. But most importantly, I've not heard somebody talk about violence. And I think that's a good thing. And as a country, I suppose we are moving forward in our democratization process. Maybe these are teething problems. We're only 60 years old. The United States is over 200 years. And you saw what happened. So we shall keep trying to hone our skill and make our democracy better. I believe and I have hope in you, the people of Uganda. We shall get there. Good night and God bless Uganda.